World Logical Association, in cooperation with Unconscionable Times Media. Abuses ingrained in society. The research of you. Senate Judiciary Committee Mueller report hearing. Witness Attorney General William Barr, May 1st, 2019. This is the U.S. Senate detectives assigned to your case. Was Donald Trump involved in any way with the crime of your favorite thing? The witness, Mr. Barr, is the United States Attorney General, hired by Donald Trump just months ago. The Attorney General is the head lawyer for the United States government. Mr. Mueller's report went to Mr. Barr first. Mr. Barr decided to send out to the public a 4-page summary of what Mr. Mueller's 448-page report of over 2 years of investigations concluded. However, Mr. Barr was hired by Donald Trump to be in this exact location, as both were long aware of the crimes Donald Trump would be dealing with. Mr. Barr is the top of that chain of control. Get it? As you will learn, anyone willing to assist Donald Trump in any way whatsoever is either conned or deluded or an unconscionable, where predatory actions simply do not bother them. So rinse and repeat is a breeze, and a power charge. Like the others you have witnessed in the Michael Cohen meeting, so you will meet some of their counterparts in the Senate. Just notice agenda. The same? If so, what's the point of the different bodies of government? Which once again equals no choice. Just remove the backgrounds and the actions of evil are identical. No choice. Con doesn't matter. Just the results. By now, you should be able to recognize the difference between attempts at resolve and demands of constant chaos by confusing citizens and intentionally not clearing things up and using taxpayer money to do so. Systematic abuses and violations. This did not just start. Hell no. Only a very small portion of the recognition appeared, which equals reality. USA is programmed to wait until after the fact, then complain to feel good. An APA next chapter scam. Let's get to the show. The Senate is up to bat. Now, there are over 20 of the bullies, Donald Trump's buddies, in that same schoolyard that have either admitted to lying to federal agents or committed another criminal act. All are connected to Donnie. Unconscionables must lie, con forever. You will notice even if you watch Donnie steal your favorite thing, these unconscionables will tell you it was a weather balloon, a donkey, anything but reality. Trapped in psycho logic forever, these beings are trapped outside reality forever. So they must keep everyone there. Get it? Psychociety equals normal. So these detectives that are making a bunch of crap up to confuse you and your parents are basically saying no matter what evidence you have on Donnie, he was never involved with any of these people and he was never even in the schoolyard. And your favorite thing is not even missing, saying you are crazy. So if you say any truths about them, you will be attacked and called crazy, known as allegations equals confessions. Pay attention as they must repeat abusing you. They must 100% ignore all evidence and redirect. Their conspiracy equals raping humanity. Notice the backhanded fraud and false statements only to con citizens. A conscience could never do what unconscionables do with no shame. They so easily repeat lies, deceit, fraud, abuse, bully, con, as it does not bother them. They are machines, con machines. No feel except for themselves. They actually think abusing is funny. Unconscionable's joy is derived from your upset. They need you to need. Need what? Does not matter. So long as your brain is occupied with need, you are never going anywhere. hence the prison ball you call Earth. Anything progressive moving forward is hidden. Cons of cons. So you keep treading water. USA thinks they are the first to be informed of things like technology, etc., when in fact, with many things kept 10 to 20 years behind others, treated like children by psychosis, because they are Donnies. They must suppress/oppress others for control. In short, start to notice what lines up with the point of what it's about and the covert conning repeated as trap rats must do forever. Then get you to somehow think they are concern and not sales of concern, to keep you in need like Donnie. They have no real skills, just con. Many are lawyers and call that a skill. That's a confession of a real con. Layers of con. Thanks for that pre-confession. Lawyers, like police in the United States of psychosis, benefit by creating problems within society or dealing with another lawyer's slime. Either way, they both benefit. What they are trained to do is go around shit. Loopholes equal fraud holes. The more they abuse society, the smarter they are in Psychosociety USA. At APA Design, abuse equals advance equals quiet. Location, location, location. Talk about location, location, location. This Senate meeting with Mr. Barr was demanded as Mr. Barr is obviously using the office as a tool for unconscionables. Sound familiar? The Mueller report was hijacked by Mr. Barr and Team Evil. Their required alienation of reality attempt did not go as planned. Mr. Barr must now answer questions regarding his role in what he did and provided regarding Mr. Mueller's report. Again, I will put some notes along the way. Always remember, these are very small dissections. The point is to learn to fish through the fraud and cons. Also, thanks to evil, there are always loads to find and always more added with each breath. You will easily notice the Congress, the Senate, the courts, none of that matters. All backgrounds hiding the playing field equals same agenda. All that really matters is what's their agenda and location, location, location. Control, control, control. Therefore, unconscionables have it where there are not really separate bodies of protection. That's bullshit. See Grommet Factory. They cover the landscape horizontally and vertically via location stations. Let's see what kind of samples of fraud will be confessed in this meeting. Trapped in retroactive forever.
Thank you. Here we come to order, and the first order of business is to try to cool the room down, so we'll see if we can do that. But the Attorney General will be testifying here in a bit about the Mueller report. And I want to thank him for coming to the committee and giving us an explanation as to the actions he took and why he took them regarding the Mueller report. And here's the good news. Here's the Mueller report. You can read it for yourself. It's about 400 and something pages. Can't say I've read it all, but I've read most of it. There's an unredacted version over in the classified section of the Senate, a room where you can go look at the unredacted version, and I did that, and I found it not to change anything in terms of an outcome. But a bit about the Mueller report. Who is Mueller? For those who may not know, I don't know where you've been, but you may not know, that Bob Mueller has a reputation in this town and throughout the country as being an outstanding lawyer and a man of the law. He was the FBI director. He was the Deputy Attorney General. He was in charge of the Criminal Division at the Department of Justice. He was a United States Marine, and he has served his country in a variety of circumstances, long and well. For those who took time to read the report, I think it was well written, very thorough. And let me tell you what went into this report. There were 19 lawyers employed, approximately 40 FBI agents, intel analysts, forensic accountants, and other staff, 2,800 subpoenas issued, 500 witnesses interviewed, 500 search warrants executed, more than 230 orders for communication records so records could be obtained, 13 requests to foreign governments for evidence, over $25 million spent over 2 years. We may not agree on much, but I hope we can agree that he had ample resources, took a lot of time, and talked to a lot of people. And you can read for yourself what he found. The Attorney General will tell us a bit about what his opinion of the report is. In terms of interacting with the White House turned over to Mr. Mueller 1.4 million documents and records, never asserted executive privilege one time. Over 20 White House staffers, including 8 from the White House counsel's office, were interviewed voluntarily. Don McGahn, chief counsel for the White House, was interviewed for over 30 hours. Everybody that they wanted to talk to from the Trump campaign on the ground, they were able to talk to. The president submitted himself to written interrogatories. So to the American people, Mr. Mueller was the right guy to do this job. I always believed that Attorney General Sessions was conflicted out because he was part of the campaign. He was the right guy with ample resources, and the cooperation he needed to find out what happened was given, in my view. But there were 2 campaigns in 2016, and we'll talk about the second one in a minute. So what have we learned from this report? After all this time and all this money, Mr. Mueller and his team concluded there was no collusion. I didn't know. Like many of you here, on the Republican side, we all agreed that Mr. Mueller should be allowed to do his job without interference. I joined with some colleagues on the other side to introduce legislation to protect the special counsel, that he could only be removed for cause. He was never removed. He was allowed to do his job. So no collusion, no coordination, no conspiracy between the Trump campaign and the Russian government regarding the 2016 election. As to obstruction of justice, Mr. Mueller left it to Mr. Barr to decide after years and all this time. He said, Mr. Barr, you decide. Mr. Barr did. There are a bunch of lawyers on this committee, and I will tell you the following. You have to have specific intent to obstruct justice. If there's no underlying crime, pretty hard to figure out what intent might be if there was never a crime to begin with. The president never did anything to stop Mueller from doing his job. So I guess the theory goes now, okay, he didn't collude with the Russians and he didn't specifically do anything to stop Mueller, but attempted obstruction of justice of a crime that never occurred, I guess, is sort of the new standard around here. We'll see if that makes any sense. To me, it doesn't. Now, there's another campaign. It was the Clinton campaign. What have we learned from this report? The Russians interfered in our election. So can some bipartisanship come out of this? I hope so. I intend to work with my colleagues on the other side to introduce the Deter Act and to introduce legislation to defend the integrity of the voting system. Senator Durbin and I have legislation that would deny anyone admittance into the United States a visa through the immigration system if they were involved in interfering in an American election. I'm working with Senator Whitehouse and Blumenthal to make sure that if you hack into a state election system, even though it's not tied to the internet, that's a crime. I would like to do more to harden our infrastructure because the Russians did it. It wasn't some 400-pound guy sitting on a bed somewhere. It was the Russians. And they're still doing it. And it could be the Chinese, it could be somebody next. So my takeaway from this report is that we've got a lot of work to do to defend democracy against the Russians and other bad actors. And I promise the committee we will get on with that work, hopefully in a bipartisan fashion. The other campaign. The other campaign was investigated not by Mr. Mueller, by people within the Department of Justice. The accusation against the Clinton, Secretary Clinton, was that she set a private server up somewhere in her house and classified information was on it to avoid the disclosure requirements and the transparency requirements required of being Secretary of State. So that was investigated. What do we know? We know that the person in charge of investigating hated Trump's guts. I don't know how Mr. Mueller felt about Trump, but I don't think anybody on our side believes that he had a personal animosity toward the president to the point he couldn't do his job. This is what Strzok said on February the 12th, 2016. Now, he's in charge of the Clinton email investigation. Oh, he's Trump's abysmal. I keep hoping the charade will end and people will just dump him. February the 12th, 2016. Page is the Department of Justice lawyer assigned to this case. March 3rd, 2016. God, Trump is a loathsome human being. Strzok. Oh my God, Trump's an idiot. Page, he's awful. Strzok. God, Hillary should win 100 million to nothing. Compare those two people to Mueller. March 16th, 2016. I cannot believe Trump is likely to be an actual serious candidate for president. July the 21st, 2016. Trump is a disaster. I have no idea how destabilizing his presidency would be. August the 8th, 2016. 3 days before Strzok was made deputy acting in charge of the counterintelligence division of the FBI. He's never going to become president, right? Page to Strzok. No, he won't. We'll stop him. These are the people investigating the Clinton email situation and start the counterintelligence investigation of the Trump campaign. Compare them to Mueller. August the 15th, 2016. Strzok. I want to believe the path you threw out for consideration in Andy's office, that there's no way he gets elected, but I'm afraid we can't take that risk. It's like an insurance policy in the event you die before you're 40. August 26, 2016. Just went to the Southern Virginia Walmart. I could smell the Trump support. October the 19th, 2016. Trump is a fucking idiot. He's unable to provide a coherent answer. Sorry to the kids out there. These are the people that made a decision that Clinton didn't do anything wrong and a counterintelligence investigation of the Trump campaign was warranted. We're going to, in a bipartisan way, I hope, deal with Russia. But when the Mueller report is put to bed, and it soon will be, this committee is going to look long and hard at how this all started. We're going to look at the FISA warrant process. Did Russia provide Christopher Steele the information about Trump that turned out to be garbage that was used to get a warrant on an American citizen? And if so, how did the system fail? Was there a real effort between Papadopoulos and anybody in Russia to use the Clinton emails stole by the Russians, or was that thought planted in his mind? I don't know, but we're going to look. And I can tell you this, if you change the names, y'all would want to look too. Everything I just said, just substitute Clinton for Trump. And see what all these people with cameras would be saying out here about this. As to cooperation, in the Clinton investigation. I told you what the Trump people did. I'll tell you a little bit about what the Clinton people did. There was a protective order for the server issued by the House, and there was a request by the State Department to preserve all the information on the server. Paul Gambetta, after having the protective order, used a software program called BleachBit to wipe this email server clean. Has anybody ever heard of Paul Gambetta? No. Under protective order from the House to preserve the information, under a request from the State Department to preserve the information on the server, he used a BleachBit program to wipe it clean. What happened to him? Nothing. 18 devices possessed by Secretary Clinton she used to do business as secretary. How many of them were turned over to the FBI? None. 2 of them couldn't be turned over because Judith Casper took a hammer and destroyed 2 of them. What happened to her? Nothing. So the bottom line is, we're about to hear from Mr. Barr the results of a 2-year investigation into the Trump campaign, all things Russia, the actions the president took before and after the campaign, $25 million, 40 FBI agents. I appreciate very much what Mr. Mueller did for the country. I have read most of the report. For me, it is over. Senator Feinstein.
Thank you, Mr. Chairman, and welcome, Attorney General. On March 24th, you sent a letter to Chairman Graham and the ranking member of this committee, providing your summary of the principal conclusions set out in Special Counsel Mueller's report. This letter was widely reported as a win for the president and was characterized as confirming there was no conclusion. Following this letter, the White House put out a statement declaring the special counsel, and I quote, "The special counsel did not find any collusion and did not find any obstruction," end quote, and that the report, quote, "was a total and complete exoneration," end quote, of the president. However, last night, the Washington Post reported that Special Counsel Mueller sent you a letter in late March where he said your letter to Congress failed to, quote, fully capture the context, nature, and substance of his office's work and conclusions, end quote, and that he spoke with you about the concern that the letter threatened to undermine the public confidence in the outcome of the investigations. That's in quotes as well. Then on April 18th, you held a press conference where you announced repeatedly that the Mueller report found no collusion and no evidence of a crime. An hour later, a redacted copy of the Mueller report was provided to the public and the Congress, and we saw why Mueller was concerned. Contrary to the declarations of the total and complete exoneration, the special counsel's report contained substantial evidence of misconduct. First, special counsel Mueller's report confirms that the Russian government implemented a social media campaign to mislead millions of Americans, and that Russian intelligence services hacked into the DNC and the DCCC computers, stole emails and memos, and systematically released them to impact the presidential election. Your March letter stated that there was no evidence that the Trump campaign, quote, conspired or coordinated with Russia, end quote. However, the report outlined substantial evidence that the Trump campaign welcomed, encouraged, and expected to benefit electorally from Russia's interference in the election. The Mueller report also details how time and time again the Trump campaign took steps to gain advantage from Russia's unlawful interference. For example, President Trump's campaign manager, Paul Manafort, passed internal campaign polling data, messaging, and strategy updates to Konstantin Kilimnik, a Russian national with ties to Russian intelligence. The Mueller report explains how Paul Manafort briefed Kilimnik in early August of 2016 on, and I quote, the state of the Trump campaign and Manafort's plan to win the election, end quote, including the campaign's focus on the battleground states of Michigan, Wisconsin, Pennsylvania, and Minnesota. Next, the Mueller report documents the Trump campaign's communications regarding Secretary Clinton's and the DNC's stolen emails. Specifically, the report states, and I quote, within approximately 5 hours of President Trump calling on Russia to find Secretary Clinton's emails, Russian intelligence agency GRU officers, quote, targeted for the first time Clinton's personal office, end quote. The Mueller report also reveals that President Trump repeatedly asked individuals affiliated with his campaign, including Michael Flynn, quote, to find the deleted Clinton emails, end quote. These efforts included suggestions to contact foreign intelligence services, Russian hackers, and individuals on the dark web. The report confirms that Trump knew of WikiLeaks releases of the stolen emails and received status updates about upcoming releases, while his campaign promoted coverage of the leaks. Donald Trump Jr. communicated directly with WikiLeaks and at its request publicly tweeted a link to emails stolen from Clinton's campaign manager. Second, in your March letter to Congress, you concluded, and I quote, that the evidence is not sufficient to establish that the president committed an obstruction of justice offense, end quote. However, Special Counsel Mueller methodically outlines 10 episodes, some continuing multiple actions by the president to mislead the American people and interfere with the investigations into Russian interference and obstruction. In one example, the president repeatedly called White House counsel Don McGahn at home and directed him to fire Mueller, saying, quote, "Mueller has to go. Call me back when you do it." Then later, the president repeatedly ordered McGahn to release a press statement and write a letter saying the president did not order Mueller fired. The Mueller report also outlines efforts by President Trump to influence witness testimony and deter cooperation with law enforcement. For example, the president's team communicated to witnesses that pardons would be available if they, quote, "stayed on message," end quote, and remained, quote, "on the team," end quote. In one case, the president sent messages through his personal lawyers to Paul Manafort that he would be taken care of and just, quote, "sit tight," end quote. The president then publicly affirmed this communication by stating that Manafort was, quote, "a brave man," end quote, for refusing to break. Similarly, the Mueller report stated the president used inducements in the form of positive messages in an effort to get Michael Cohen not to cooperate, and then turned to attacks and intimidation to deter the provision of information or undermine Cohen's credibility. Finally, while the March letter to Congress and the April press conference left the impression there were no remaining questions to examine, this report notes several limitations Mueller faced while gathering the facts that Congress needed to examine. More than once, the report documents that legal conclusions were not drawn because witnesses refused to answer questions or failed to recall the events. In addition, numerous witnesses, including but not limited to Jared Kushner, Sarah Sanders, Rudolph Giuliani, Steve Bannon, and John Kelly, all stated they could not recall events. The president himself said more than 30 times that he could not recall or remember enough to be able to answer written questions from the special counsel. The special counsel also recounted that, quote, "some associated with the Trump campaign deleted relevant communications or communicated during the relevant period using applications that featured encryption or do not provide for long-term retention of data," end quote. Based on these gaps, the Mueller report concluded, and I quote again, "the office cannot rule out the possibility that the unavailable information would have shed additional light on or cast a new light on events described in the report," end quote. And contrary to the conclusion that the special counsel's report did not find evidence of communication or coordination between the Trump campaign and Russia, the Mueller report explicitly states, and I quote, "a statement that the investigation did not establish particular facts does not mean there was no evidence of those facts." Volume 2, page 2. Let me conclude with this. Congress has both the constitutional duty and the authority to investigate the serious findings contained in the Mueller report. I strongly believe that this committee needs to hear directly from Special Counsel Mueller about his views on the report in his March letter. I also believe senators should have the opportunity to ask him about these subjects in questions directly. I have requested this to our chairman to authorize a hearing with Special Counsel Mueller, and I hope that will happen soon. Thank you, Mr. Chairman.
Thank you. Before we receive your testimony, Mr. Barr, we have the letter that Mr. Mueller sent to you on March 27th, 2019. I'll put that in the record now. The floor is yours. What? Got to swear you in? Sorry. You do solemnly swear the testimony you're about to give this committee is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Sorry about that.
Thank you, Mr. Chairman and Ranking Member Feinstein, members of the committee. During my confirmation process, there were two concerns that dominated, as I think you will all agree. The first was whether I would in any way impede or curtail Special Counsel Mueller's investigation, and the second, whether I would make public his final report. As you see, Bob Mueller was allowed to complete his work as he saw fit. And as to the report, even though the applicable regulations require that the report is to be made to the AG and is to remain confidential and not be made public, I told this committee that I intended to exercise whatever discretion I had to make as much of the report available to the public and to congressional leaders as I could, consistent with the law. This has been done. I arrived at the department on February 14th, and shortly thereafter, I asked it to be communicated to Bob Mueller's team that in preparing the report, we requested that they make it so we could readily identify 6E material, so we could quickly process the report.
Could you tell the public what 6E is?
6E is grand jury material that cannot be made public. It's prohibited by statute. And I wanted that identified so we could redact that material and prepare the report for public release as quickly as we could. When I arrived at the department, I found, and was eventually briefed in on the investigation, I found that the Deputy Attorney General and his principal associate deputy, Ed O'Callahan, were in regular discussions with the counsel's office, had been, and they communicated this request and had discussions about both the report and the nature of the report. On March 5th, I met with Bob at the suggestion of the deputy and the principal associate deputy, Bob Mueller. I met with Bob Mueller to get a readout on what his conclusions would be. On March 25th, and at that meeting, I reiterated to Special Counsel Mueller that in order to have the shortest possible time before I was in a position to release the report, I asked that they identify 6E material. When I received the report on March 22nd, and we were hoping to have that easily identified, the 6E material, unfortunately, it did not come in that form. And it quickly became apparent that it would take about 3 or 4 weeks to identify that material and other material that have to be redacted. So there was necessarily going to be a gap between the receipt of the report and getting the full report out publicly. The deputy and I identified 4 categories of information that we believe required redaction. And I think you all know of them, but they were the grand jury material, the 6E material, information that the intelligence community advised would reveal sensitive sources and methods, information that if revealed at this stage would impinge on the investigation or prosecution of related cases, and information that would unfairly affect the privacy and reputational interests of peripheral third parties. We went about redacting this material in concert with the special counsel's office. We needed their assistance to identify the 6E material in particular. The redactions were all carried out by DOJ lawyers with special counsel lawyers in consultation with intelligence community. The report contained a substantial amount of material over which the president could have asserted executive privilege, but the president made the decision not to assert executive privilege and to make public of the report as we could, subject to the redactions that we thought required. Now, as you see, the report has been lightly redacted. The public version has been estimated to have only 10% redactions. Almost the vast bulk of those redactions are in Volume 1, which is the volume that deals with collusion, and it relates to existing ongoing cases. Volume 2 has only about 2% redactions for the public version, so 98% of Volume 2, dealing with obstruction, is available to the public. We have made a version of the report available to congressional leaders that only contains redactions of grand jury material. For this version, overall redactions are less than 2% for the whole report, and for Volume 2, dealing with obstruction, they are less than 0.1%. So given the limited nature of redactions, I believe that the publicly released report will allow every American to understand the results of the special counsel's work. By now, everyone is familiar with the special counsel's bottom line conclusions about Russian attempts to interfere in the election. In Volume 1, the special counsel found that the Russians engaged in two distinct schemes. First, the Internet Research Agency, a Russian entity with close ties to the Russian government, conducted a disinformation and social media operation to sow discord among Americans. Second, the GRU, Russian military intelligence, hacked into computers and stole emails from individuals affiliated with the Democratic Party and Hillary Clinton's campaign. The special counsel investigated whether anyone affiliated with President Trump's campaign conspired or coordinated with these criminal schemes. They concluded that there was not sufficient evidence to establish that there had been any conspiracy or coordination with the Russian government or the IRA. As you know, Volume 2 of his report dealt with obstruction, and the special counsel considered whether certain actions of the president could amount to obstruction. Conclusion. Instead, the report recounts 10 episodes and discusses potential legal theories for connecting the president's actions to elements of obstruction offenses. Now, we first heard that the special counsel's decision not to decide the obstruction issue at the March 5th meeting when he came over to the department, and we were frankly surprised that they were not going to reach a decision on obstruction. And we asked them a lot about the reasoning behind this and the basis for this. Special Counsel Mueller stated 3 times to us in that meeting in response to our questioning that he emphatically was not saying that but for the OLC opinion, he would have found obstruction. He said that in the future, the facts of a case against the president might be such that a special counsel would recommend abandoning the OLC opinion, but this is not such a case. We did not understand exactly why the special counsel was not reaching a decision. And when we pressed him on it, he said that his team was still formulating the explanation. Once we heard that the special counsel was not reaching a conclusion on obstruction, the deputy and I discussed and agreed that the department had to reach a decision. We had the responsibility to assess the evidence as set forth in the report and to make the judgment. I say this because the special counsel was appointed to carry out the investigative and prosecutorial functions of the department and to do it as part of the Department of Justice. The powers he was using, including the power of using a grand jury and using compulsory process, exist for that purpose, the function of the Department of Justice in this arena, which is to determine whether or not there has been criminal conduct. It's a binary decision. Is there enough evidence to show a crime? And do we believe a crime has been committed? We don't conduct criminal investigations just to collect information and put it out to the public. We do so to make a decision. And here we thought there was an additional reason, which is this was a very public investigation. And we had made clear that the results of the investigation were going to be made public. And the deputy and I felt that the evidence developed by the special counsel was not sufficient to establish a crime, and therefore it would be irresponsible and unfair for the department to release a report without stating the department's conclusions, and thus leave it hanging as to whether the department considered there had been criminal conduct. So the Deputy Attorney General and I conducted a careful review of the report with our staffs and legal advisors. And while we disagreed with some of the legal theories and felt that many of the episodes discussed in the report would not constitute obstruction as a matter of law, we didn't rest our decision on that. We took each of the 10 episodes and we assessed them against the analytical framework that had been set forth by the special counsel, and we concluded that the evidence developed during the special counsel's investigation was not sufficient to establish that the president committed an obstruction of justice offense. Let me just talk a little bit about this March 24th letter and Bob Mueller's letter, I think, on the which I received on the 28th. When the report came in on the 22nd and we saw it was going to take a great deal of time to get it out to the public, I made the determination that we had to put out some information about the bottom line. The body politic was in a high state of agitation. There was massive interest in learning what the bottom line results of Bob Mueller's investigation was, particularly as to collusion. Former government officials were confidently predicting that the president and members of his family were going to be indicted. There were people suggesting that if it took any time to turn around the report and get it out, it would mean that the president was in legal jeopardy. So I didn't feel that it was in the public interest to allow this to go on for several weeks without saying anything. And so I decided to simply state what the bottom line conclusions were, which is what the department normally does, make a binary determination. Is there a crime or isn't there a crime? We prepared the letter for that purpose, to state the bottom line conclusions. We used the language from the report to state those bottom line conclusions. I analogize it to announcing after an verdict of the trial is, pending release of the full transcript. That's what we were trying to do, notify the people as to the bottom line conclusion. We were not trying to summarize the 410-page report. So we released that. I offered Bob Mueller the opportunity to review that letter before it went out, and he declined. On Thursday morning, I received, it probably was received at the department Wednesday night or evening, but on Thursday morning, I received a letter from Bob, the letter that's just been put into the record. And I called Bob and said, you know, what's the issue here? And I asked him if he was suggesting that the March 24th letter was inaccurate, and he said no, but that the press reporting had been inaccurate, and that the press was reading too much into it. And I asked him, you know, specifically what his concern was, and he said that his concern focused on his explanation of why he did not reach a conclusion on obstruction, and he wanted more put out on that issue. He argued for putting out summaries of each volume, the executive summaries that had been written by his office. And if not that, then other material that focused on the issue of why he didn't reach the obstruction question. But he was very clear with me that he was not suggesting that we had misrepresented his report. I told Bob that I was not interested in putting out summaries, and I wasn't going to put out the report piecemeal. I wanted to get the whole report out, and I thought summaries by very definition, regardless of who prepared them, would be under-inclusive, and we'd have sort of a series of different debates and public discord over each tranche of information that went out, and I wanted to get everything out at once, and we should start working on that. And so the following day, I put out a letter explaining the process we were following and stressing that the March 24th letter was not a summary of the report, but a statement of the principal conclusions. and that people would be able to see Bob Mueller's entire thinking when the report was made public. So I'll end my statement there, Mr. Chairman, and glad to take any questions.
Thank you very much. As to the actual report itself, was there ever an occasion where you wanted to, something was redacted from the report that Mr. Mueller objected to?
I wouldn't say objected to. My understanding is the categories were defined by me and the deputy. I don't think that I have no, I don't believe.
Did you work with him to redact the report?
Right. Those categories were executed by DOJ lawyers working with his lawyers. I think there were maybe a few judgment calls, very few, as to whether or not something as a prudential matter should be treated as a reputational interest or something. So there may have been some occasions of that, but as far as I'm aware.
I understand it, you did not want to hurt somebody's reputation unless it really affected the outcome. Is that correct?
Right.
So was there any disagreement about 6E material?
Not that I'm aware of.
Any disagreement about classified information?
Not that I'm aware of.
Okay. So the conclusions in your four-page summary, you think, accurately reflect his bottom line on collusion. Is that correct?
Yes.
And you can read it for yourself if you got any doubt. As to obstruction of justice, were you surprised he was going to let you decide?
Yes, I was surprised. I think the function he was carrying out, the investigative and prosecutive function, is performed for the purpose of making that. How many people did he
actually indict? Do you know?
I can't remember off the top of my head.
It was a lot.
Yeah.
So he actually has the ability to indict if he wants to. He's used that power during the investigation. Is that correct?
That's correct. And the other thing that was confusing to me is that the investigation carried on for a while as additional episodes were looked into, episodes involving the president. And so my question is, or was, why were those investigated if at the end of the day you weren't going to reach a decision on them?
So did you consult Deputy Attorney General Rosenstein about the obstruction matter?
Constantly, yeah.
So was he in agreement with your decision not to proceed forward?
Yes. I'm sorry, the agreement what?
Not to proceed forward with obstruction.
Right.
Okay. So very quickly, give us your reasoning why you think it would be investigation. Is that correct?
That's correct. And the other thing that was confusing to me is that the investigation carried on for a while as additional episodes were looked into. A case typically has two aspects to it. One, there's usually an underlying criminality.
Let's stop right there.
Yeah.
Was there an underlying crime here?
No.
So usually there is.
Usually. But it's not necessary, but the typical case, sort of the paradigmatic case is there's an underlying crime, and then the person implicated or people implicated are concerned about that criminality being discovered, take an inherently malignant act, as the Supreme Court has said, to obstruct that investigation,
so
such
one
as
of the
destroying documents.
That people were worried about, that he fired Comey to stop the Russian investigation. That's one of the concerns people had. Let me tell you a little bit about Comey. I do not have confidence in him, Comey, any longer. That was Chuck Schumer, November the 2nd, 2016. I think he, Comey, should take a hard look at what he has done, and I think it would not be a bad thing for the American people if he did step down. Bernie Sanders, January the 15th, 2017. The president ought to fire Comey immediately, and he ought to initiate an investigation. That is Congressman Nadler, November the 14th, 2016. Did you have a problem with the way Comey handled the Clinton email investigation?
Yes, I said so at the time.
Okay. So given the fact that a lot of people, Comey should be fired, did you find that to be a persuasive act of obstructing justice?
No. I think even the report at the end of the day, came to the conclusion, if you read the analysis, that a reason that loomed large there for his termination was his refusal to tell the public what he was privately telling the president, which was that the president was not under investigation.
As to where we go forward, as to how we go forward, would you recommend that this committee and every other committee of Congress do our best to harden our infrastructure against future Russian attacks?
Absolutely, yes.
Do you think Russia is still up to it?
Yes.
Do you think other countries may get involved in our elections in 2020?
Yes.
So you would support an effort by Congress working with the administration to harden our electoral infrastructure?
Yes.
Is that one of the takeaways of the Mueller report?
Yes.
Do you share my concerns about the FISA warrant process?
Yes.
Do you share my concerns about the counterintelligence investigation, how it was opened and why it was opened?
Yes.
Do you share my concerns that the lack of professionalism in the Clinton email investigation is something we should all look at?
Yes.
Do you expect to change your mind about the bottom line conclusions of the Mueller report?
No.
Do you know Bob Mueller?
Yes.
Do you trust him?
Yes.
How long have you known him?
30 years, roughly.
You think he had the time he needed?
Yes.
You think he had the money he needed?
Yes.
You think he had the resources he needed?
Yes.
You think he did a thorough job?
Yes, and I think he feels he did a thorough job and had adequate evidence to make the calls.
Do you think the president's campaign in 2016 was thoroughly looked at in terms of whether or not they colluded with the Russians?
Yes.
And the answer is no, according to Bob Mueller.
That's right.
He couldn't decide about obstruction. You did. Is that correct?
That's right.
You feel good about your decision?
Absolutely.
Thank you very much.
Chairman, Mr. Attorney General, the special counsel's report describes how the president directed White House counsel Don McGahn to fire special counsel Mueller and later told McGahn to write a letter, quote, for our records, end quote, stating that the president had not ordered him to fire Mueller. The report also recounts how the president made repeated efforts to get McGahn to change his story. Knowing that McGahn believed the president's version of events was false, the special counsel found, and I quote, substantial evidence, end quote, that the president tried to change McGahn's account in order to prevent further scrutiny of the president towards the investigation. Special counsel also found that McGahn is a credible witness with no motive to lie or exaggerate, given the position he held in the White House. Here's the question. Does existing law prohibit efforts to get a witness to lie, to say something the witness believes is false?
Yes.
And
Lie to the government, yes.
And what law is that?
Obstruction statutes.
The obstruction statute. And you don't have it, I guess, before you.
Well, I'm not sure which one they were referring to here. It was probably 1512C2.
So these things, in effect, constitute obstruction.
Well, you're talking in general terms. You're not talking.
What I'm talking about specifically, yes, you're correct in a sense that the special counsel in his report found substantial evidence that the president tried to change McGahn's account in order to prevent, and this is a quote, further scrutiny of the president toward the investigation, end quote. The special counsel also found McGahn is a credible witness with no motive to lie or exaggerate. So what I'm asking you then, is that a credible charge under the obstruction statute?
We felt that episode be able to establish obstruction. If you go back and if you look at the episode where McGahn, the president gave McGahn an instruction. McGahn's version of that is quite clear, and each time he gave it, which is that the instruction said, go to Rosenstein, raise the issue of conflict of interest, and Mueller has to go because of this conflict of interest. So there's no question that whatever instruction was giving McGahn had to do with Mueller's conflict of interest. Now, the president later said that what he meant was that the conflict of interest should be raised with Rosenstein, but the decision should be left with Rosenstein. On the other end of the spectrum, it appears that McGahn felt it was more directive and that the president was essentially saying, push Rosenstein to invoke a conflict of interest to push Mueller out. Wherever it fell on that spectrum of interest, the New York Times story was very different. The New York Times story said flat out that the president directed the firing of Mueller. He told McGahn, fire Mueller. Now, there's something very different between firing a special counsel outright, which suggests ending the investigation, and having a special counsel removed for conflict, which suggests that you're going to have another special counsel. So the fact is that even under McGahn's, and then, as the report says and recognizes, there is evidence the president truly felt that the Times article was inaccurate, and he wanted McGahn to correct it. So we believe that it would be impossible for the government to establish beyond a reasonable doubt that the president understood that he was instructing McGahn to say something false, because it wasn't necessarily false. Moreover, McGahn had weeks before already given testimony to the special counsel, and the president was aware of that. And as the report indicates, it could also have been the case that that he was primarily concerned about press reports and making it clear that he never outright directed the firing of Mueller. So in terms of the request to ask McGahn to memorialize that fact, we do not think in this case that the government could show corrupt intent beyond a reasonable doubt.
Just to finish this, but you still have a situation where a president essentially tries to change the lawyer's account in order to prevent further criticism of himself.
Well, that's not a crime.
So you can, in this situation, instruct someone to lie?
No, it has to be, well, to be obstruction of justice, the lie has to be tied to impairing the evidence in a particular proceeding. McGahn had already given his evidence, and I think it would be plausible that the purpose of McGahn memorializing what the president was asking was to make the record that the president never directed him to fire. And there is a distinction between saying to someone, go fire him, go fire Mueller, and saying, have him removed based on conflict.
And what would
They have different results.
What would that conflict be?
Well, the difference between them is if you remove someone for a conflict of interest, then there would be presumably another person appointed.
Yeah, but wouldn't you have to have it in this kind of situation, an identifiable conflict that made sense, or else doesn't it just become a fabrication?
Well, now we're going to shift from the issue of writing the memo or somehow putting out a release later on, the issue of the actual direction to McGahn. So the question on the direction to McGahn has a number of different levels to it. And of law, I think the department's position would be that the president can direct the termination or the replacement of a special counsel. And as a matter of law, the obstruction statute does not reach that conduct. Putting that aside, the next question would be, even if it reached the conduct, could you here establish corrupt intent beyond a reasonable doubt? What makes this case very interesting is that when you take away the fact that there were no underlying criminal conduct, and you take away the fact that there was no inherently malign obstructive act, that is, the president was carrying out his constitutional duties. The question is, what is the impact of taking away the underlying crime? It's not, as the report suggests, that one impact is, well, we have to find some other reason why the president would obstruct the investigation. But there's another impact, which is, if the president is being falsely accused, which the evidence now suggests that the accusations against him were false, and he knew they were false, and he felt that this investigation was unfair, propelled by his political opponents, and was hampering his ability to govern, that is not a corrupt motive for replacing an independent counsel. So that's another reason that, you know, we would say that the government would have difficulty proving this beyond a reasonable doubt.
My time is right. Thank you.
Senator Grass.
Senator Johnson and I wrote you about text messages between Peter Strzok and Lisa Page that appear to show the FBI may have tried to use counterintelligence briefings for the Trump transition team as intelligence gathering operations. I hope you'll commit to answering the letter in writing, but also providing committees the requested briefing. That's my question.
Yes, Senator.
Have you already tasked any staff to look into whether spying by the FBI and other agencies on the Trump campaign was properly predicated? And can Congress expect a formal report on your findings?
Yes, I do have people in the department helping me review the activities over the summer of 2016.
Okay. I suppose it depends on what conclusions you come to, but is there any reason why Congress wouldn't be briefed on your conclusions?
You know, it's a little early for me to commit completely, but I envision some kind of reporting at the end of this.
The Clinton campaign and the Democrat National Committee hired Fusion GPS to do opposition research against candidate Trump. Fusion GPS then hired Christopher Steele, former British intelligence officer, to compile what we all know as the Steele dossier that reportedly used Russian government sources for information. The Steele dossier was central to the now debunked collusion narrative. Now, here's the irony. The Mueller report spent millions investigating and found no collusion between Trump campaign and Russia. But the Democrats paid for a document created by a foreign national with reported foreign government sources. Not Trump, but the Democrats. That's the definition of collusion. Despite the central status of the Steele dossier to the collusion narrative, the Mueller report failed to analyze whether the dossier was filled with disinformation to mislead U.S. intelligence agencies and the FBI. My question, Mueller spent over 2 years, $30 million investigating Russian interference in the election. In order for a full accounting of Russian interference attempts, shouldn't the special counsel have considered on whether the Steele dossier was part of a Russian disinformation and interference campaign?
I don't, you know, Special Counsel Mueller has put out his report, and I have not yet had anyone go through the full scope of his investigation. to determine whether he did address or look at all into those issues. One of the things I'm doing in my review is to try to assemble all the existing information out there about it, not only from Hill investigations and the OIG, but also to see what the special counsel looked into. So I really couldn't say what he actually looked into.
But you think, in other words, if you had looked at all that information right now, you're telling me you could have said yes or no to my question?
If I had looked at it.
Yeah. And you're going to
Yes.
attempt to find
Yes.
some of this information
Yes.
if it's available.
Yes.
Similarly, shouldn't the special counsel have looked into the origins of the FBI's investigation into alleged collusion between the Trump campaign and Russia?
The origins of that narrative?
Yes.
I don't know if he viewed his charter that broadly, and I don't know whether he did or not. That's something that I am reviewing, and again, we'll look at whatever the special counsel has developed on that.
Yeah. In volume 2 of the report, the special counsel declined to make a traditional prosecutorial decision. Instead, the special counsel laid out 200 or so pages relating to a potential obstruction analysis and then dumped that on your desk. In your press conference, you said that you asked the special counsel whether he would have made a charging decision or recommended charges on obstruction, but for the Office of Legal Counsel's opinion on charging sitting presidents, and that the special counsel made clear that was not the case. So, Mr. Barr, is that an accurate description of your conversation with the special counsel?
Yes, he reiterated several times in a group meeting that he was not saying that but for the OLC opinion, he would have found obstruction.
Yeah. If the special counsel found facts sufficient to constitute obstruction of justice, would he have stated that finding?
If he had found that, then I think he would state it, yes.
Okay. Was it special counsel Mueller's responsibility to make a charging recommendation?
I think the Deputy Attorney General and I thought it was, but not just charging, but to determine whether or not conduct was criminal. The president would be charged, could not be charged as long as he was in office.
Do you agree with the reasons that he offered for not making a decision in volume 2 of his report, and why or why not?
I'm not really sure of his reasoning. I really could not recapitulate his analysis, which is one of the reasons in my March 24th letter, I simply stated the fact that he did not reach a conclusion and didn't try to put words in his mouth. I think that if he felt that he shouldn't go down the path of making a traditional prosecutive decision, then he shouldn't have investigated. That was the time to pull up.
Okay. There have been a number of leaks coming out of the Justice Department and FBI during high-profile investigations. The Inspector General found that during the department's investigation of Hillary Clinton for mishandling highly classified information, there was a culture of unauthorized media contacts. During the Russian investigation, the leaks continued. Leaks undermined the ability of investigators to investigate. Further leaks to the papers while Congress's questions to the department go unanswered is unacceptable. Why? What are you doing to investigate unauthorized media contacts by the department and FBI officials during the Russian investigation?
We have multiple criminal leak investigations underway.
Thank you.
Senator Lee.
Thank you, Attorney General. I'm somewhat troubled by your testimony here and in the other body. You appeared before the House Appropriations on April 9th. You were asked about media reports that portrayed the special counsel's team as frustrated that your March 24th letter didn't adequately portray the report's findings. When the congressman, I believe it was Congressman Chris, asked if you knew what those members of the special counsel's team were concerned about. You testified in response, "No, I don't." You then said you merely suspected they would have preferred more information was released with a letter. Now we know, contrary to what you said on April 9th, that on March 27th, Robert Mueller wrote to you expressing very specific concerns that your March 24th letter, remember you're testifying on April 9th, that your March 24th letter failed to capture to quote Mr. Mueller, the context, nature, and substance, close quote, of his report. And what really struck me, Mr. Mueller wrote that your letter threatened to undermine a central purpose for which the department appointed the special counsel, to assure full public confidence in the outcome of the investigation. Why did you testify on April 9th that you didn't know the concerns being expressed by Mueller's team, when in fact you had heard those concerns directly from Mr. Mueller 2 weeks before?
Well, as I said, I talked directly to Bob Mueller about his letter to me and specifically asked him, what exactly are your concerns? Are you saying that the March 24th letter was misleading or inaccurate, or what? He indicated that it was not. He was not saying that, and that what he was concerned about.
That wasn't my question.
Well, I'm getting to the question, which is the question from Christ was, reports have emerged recently, press reports, that members of the special counsel's team are frustrated at some level with the limited information included in your March 24th letter, in that they don't adequately or accurately portray the report's findings. I don't know what members he's talking about. I certainly am not aware of any challenge to the accuracy of the findings.
Mr. Barr, you seem to have learned the filibuster rules even better than senators do. My question was, why did you say you were not aware of concerns when weeks before your testimony, Mr. Mueller had expressed concerns to you? I mean, that's a fairly simple.
Well, I answered a question, and the question was relating to unidentified members who were expressing frustration over the accuracy relating to findings. I don't know what that refers to at all. I talked directly to Bob Mueller, not members of his team, and even though I did not know what was being referred to, and Mueller had never told me that the expression of the findings was inaccurate, but I did then volunteer that I thought they were talking about the desire to have more information put out. But it wasn't my purpose to put out more information.
Well, Mr. Barr, I feel your answer was purposely misleading, and I think others do too. Let me ask you another one. You said the president is fully cooperating with an investigation, but his attorney had told a defendant he'd be taken care of if he didn't cooperate with the investigation. Is there a conflict in that?
I'm sorry, could you just repeat that?
Both Mr. Manafort and Mr. Cohen were told by Trump's personal attorney they'd be taken care of if they did not cooperate. You said that the president was fully cooperating. Is there a conflict there? Yes or no?
No.
Okay. Do you think it's fully cooperating to instruct a former aide to tell the Attorney General to unrecuse himself, shut down the investigation, and declare the president did nothing wrong?
I don't think, well, obviously, since I didn't find it was obstruction, I felt that the evidence could not support an obstruction.
I'm asking if that's fully cooperating. I'm not asking whether that's obstruction. Is that fully cooperating?
Yeah, he fully cooperated.
So by instructing a former aide to tell the Attorney General to unrecuse himself, shut down the investigation, and declare the president did nothing cooperating.
Where is that in the report?
That is on volume 2, page 5. On June 19, 2017, the president dictated a message for Lewandowski to deliver to Sessions. The message said the Sessions should publicly announce that notwithstanding his recusal from the Russia investigation, the investigation is very unfair to the president. The president did nothing wrong.
Right. Okay, so
cooperating.
Well, firstly, asking Sessions to unrecuse himself, we do not think is obstruction.
And declare the president did nothing wrong. I'm not asking you if it's obstruction. He's cooperating.
Well, I don't know if that declares the president did nothing wrong, although the president, in terms of collusion, did nothing wrong. Isn't that correct?
Well, collusion is not a crime. It's the obstructing. But is that fully cooperating to say that?
Well, I don't see any conflict between that and fully cooperating with the investigation.
The president, of course, declared many times publicly in tweets and campaign rallies and all that he would testify fully. He never did testify, correct?
As far as I know.
Well, I think you know whether he testified or not.
As far as I know, he didn't testify.
And Mr. Mueller found the written answers to be inadequate. Is that correct?
I think he wanted additional, but he never sought it.
And the president never testified.
Well, he never pushed it.
The president never testified. Does the fact that Mr. Mueller found the Trump campaign was receptive to some of the offers of assistance from Russia, or the fact that the Trump campaign never reported any of this to the FBI, does that trouble you?
What would they report to the FBI?
That they were receptive to offers of assistance from Russia.
What do you mean by receptive? I think the report says, obviously, obviously they were expecting to benefit from whatever the Russians.
Page 173, the volume 1 report says, in sum, the investigation established multiple links between Trump campaign officials and individuals tied to the Russian government. Those links included Russian offers of assistance to the campaign, and in some instances, the campaign was receptive to the offer, whereas others they were not.
Well,
that doesn't bother you at all?
Well, I have to understand exactly what that refers to, what communications that referred to.
Well, you have the report. I just gave you the page from the report, and I know my time is up, and I'm making the chairman nervous.
No, just very well done. Senator Cornyn.
General Barr, the chairman has pointed out that after the Hillary Clinton email investigation, there were a number at Mr. Comey's press conference, I think it was July the 5th, roughly 2016, there were a number of prominent Democratic members of the Senate who said that Comey should resign or be fired. I believe you said that you've concluded as a matter of law that the president, as the head of the executive branch of government, has the right to fire executive branch employees. Mm-hmm. Is that correct?
That's right.
In this case, the president was relying, at least in part, on a recommendation by the Deputy Attorney General, Rod Rosenstein, arising out of Rod Rosenstein's critique of Mr. Comey's conduct in holding that press conference, releasing derogatory information about Secretary Clinton, but then announcing that no reasonable prosecutor would bring charges against her. Is that right?
That's right.
You started your career, I believe, in the intelligence community, and then moved on, of course, to the Department of Justice. And thank you for agreeing to serve again as Attorney General and help restore the department's reputation as an impartial arbiter of the law and not as a political arm of any administration. I think that's very, very important that you and Director Wray continue your efforts in that regard, and I'm grateful to you for that. But I do believe that we need to ask the question, why didn't the Obama administration do more as early as 2014 in investigating Russian efforts to prepare to undermine and sow dissension in the 2016 election? Mr. Mueller's report document that the Russian government, through the intelligence, through their intelligence agencies and their internet research, or IRA, I think it's called, began as early as 2014, began their efforts to do so, and we know they met with some success. Is it any surprise to you, based on your experience, that the Russians would try to do everything they can to sow dissension in American political life, including in our elections?
No, not at all. I mean, I think the internet creates a lot more opportunities to have to have that kind of covert effect on American body politics. So it's getting more and more dangerous. But the Russians have been at this for a long time in various different ways. But the point you made about Bob Mueller's efforts on IRA, that's one of the things that struck me about the report. I think it's very impressive work that they did in moving quickly to get into the IRA, and also the GRU folks. And I was thinking to myself, if that had been done in 2000, starting in the beginning of 2016, we would have been a lot further along.
For example, we've heard a lot about the Steele dossier. Mr. Steele, of course, is a former British intelligence officer hired to do opposition research by the Hillary Clinton campaign on her political adversaries, including President Trump or candidate Trump at that time. How do we know that the Steele dossier is not itself evidence of Russian disinformation campaign, knowing what we know now, that basically the allegations made therein were secondhand, hearsay, or unverified? Can we state with confidence that the Steele dossier was not part of the Russian disinformation campaign?
No, I can't state that with confidence, and that is one of the areas that I'm reviewing. I'm concerned about it, and I don't think it's entirely speculative.
Well, we know that from published reports that the head of the CIA, Mr. Brennan, went to President Obama and brought his concerns about initial indications of Russian involvement in the campaign as early as the late July 2016. And instead of doing more during the Obama administration to look into that and disrupt and deter Russian activities that threatened the validity and integrity of our campaign in 2016, it appears to me that the Obama administration, Justice Department, and FBI decided to place their bets on Hillary Clinton and focus their efforts on investigating the Trump campaign. But as you have pointed out, thanks to the special counsel, we now have confidence that no Americans colluded with the Russians in their effort to undermine the American people. We now need to know, and I'm glad to hear what you are telling us about your inquiries and your research and your investigation. We now need to know what steps the Obama, FBI, Department of Justice, and intelligence community, what steps they took to undermine the political process and put a thumb on the scale in favor of one political candidate over the other, and that would be before and after the 2016 election. What's a defensive briefing that in a counterintelligence investigation?
Well, you could have different kinds of defensive briefings. If you learn that somebody is being targeted by a hostile intelligence service, then one form of defensive briefing is to go and to alert that person to the risks.
I think Attorney General Lynch has said it is routine in counterintelligence investigations. Would you agree with her?
Yes.
Do you know whether a defensive briefing was ever given to the Trump campaign by the FBI based on their counterintelligence investigation? Did they ever tell the president before he was January 2017 what the Russians were trying to do and advise him to tell people affiliated with this campaign to be on their guard and be vigilant about Russian efforts to undermine public confidence in the election?
My understanding is that didn't happen.
That would be that failure to provide a defensive briefing to the Trump campaign, that would be an extraordinary or notable failure. Would you agree?
I think under these circumstances, it's one of the things that I can't fathom why it did not happen. If you're concerned about interference in the election, and you have, substantial people involved in the campaign who were former U.S. attorneys. You had 3 former U.S. attorneys there in the campaign. I don't understand why the Bureau would not have gone and given a defensive briefing.
Thank you.
Senator Durbin.
Thanks, Mr. Chairman. Thanks, General Barr. I've been listening carefully to my Republican colleagues on the other side, and it appears that they are going to work together and coordinate the so-called locker-up defense. This is really not supposed to be about the Mueller investigation, the Russian involvement in the election, the Trump campaign, and so forth. It is really about Hillary Clinton's emails. Finally, we get down to the bottom line. Hillary Clinton's emails and questions have to be asked about Benghazi along the way. What about Travelgate, Whitewater? There's a lot of material we should be going through today according to their response to this. That is totally unresponsive to the reality of what the American people want to know. They paid a lot of money, $25 million for this report. I respect Mr. Mueller and believe he came up with a sound report, though I don't agree with all of it. But I find, General Barr, that some of the things that you've engaged in really leave me wondering what you believe your role as Attorney General is when it comes to something like this. Listen to what, since it's put in the record, let me read it. Listen to what you received in a letter on March 27th from Bob Mueller. The summary letter the department sent to Congress and released to public late in the afternoon, March 24th, did not fully capture the context, nature, and substance of the office's work and conclusions. We communicated that concern to the department on the morning of March 25th. There is now public confusion about critical aspects of the results of our investigation. This threatens to undermine a central purpose for which the department appointed the special counsel, to assure full public confidence in the outcome of the investigations. I cannot imagine that you received that letter on March 24th and could not answer Congressman Crist directly when he asked you whether there were representations being made on these findings by the people working for Bob Mueller. You said, "No, I don't know," after you received this letter. What am I missing?
Well, as I explained to Senator Leahy, I talked directly to Bob, and Bob told me that he did not have objections to the accuracy.
Attorneys don't put things in writing unless they're pretty serious about them. There's an old rule in politics: a good politician doesn't write a letter and doesn't throw one away.
Okay.
So I've got to ask you, if he puts it in writing of his concerns or your representations on March 24th, you couldn't recall that when Congressman Crist asked you that question a few days later?
No, I'm saying that this was the March 24th letter stated that Bob Mueller did not reach a conclusion on obstruction. And it had the language in there about not exonerating the president. My view of events was that there was a lot of criticism of the special counsel for the ensuing few days. And on Thursday, I got this letter. And when I talked to the special counsel about the letter, my understanding was his concern was not the accuracy of the statement of the findings in my letter, but that he wanted more out there to provide additional context to explain his reasoning on why he didn't reach a decision on obstruction.
I'll just say this, Mr. Barr. If you received a letter from Bob Mueller a few days after your March 24th letter, it was clear he had some genuine concerns about what you had said and done to that point. Can we move to another topic?
Yeah, his concerns was he wanted more out. And I would analogize it to this. After a months-long trial, if I wanted to go out and get out to the public what the verdict was, pending preparation of the full transcript, and I'm out there saying, here's the verdict, and the prosecutor comes up and taps me on the shoulder and says, well, the verdict doesn't really fully capture all my work. How about that great, cross-examination I did, or how about that third day of trial where I did that? This doesn't capture everything. My answer to that is I'm not trying to capture everything. I'm just trying to
absolutely use the word summarize, though, in your letter.
Summarize the principal conclusions.
Principal conclusions, which most people would view as a summary. But let me move to another topic if I can for a minute. The Office of Legal Counsel's decision as to whether or not you can prosecute a sitting president, you had some pretty strong feelings of that, and they were reflected in your volunteered memo to the Trump defense team, your 19-page memo.
Did I discuss that?
You certainly discussed whether or not a president should cooperate with an investigation. You said at one point in summarizing the findings of Mueller that the White House fully cooperated. We know for a fact, and you've stated already, the president never submitted himself to what was characterized as a vital interview, an actual sit-down interview under oath, not once, and that his questions that were answered some 30 times, his memory failed him. So to say the White House fully cooperated that, I think, is a generous conclusion. On this Office of Legal Counsel, I would refer you to this volume 2 of the Mueller report, and on page 1, he talks about the whole issue of whether or not he was in any way restricted and what he could conclude because of the outstanding Office of Legal Counsel opinion on the liability of a sitting president. You dismissed that in your opening statement and said we asked him 2 or 3 times. He said that had nothing to do with it. Well, how do you explain on the first page of volume 2 that he says it had a lot to do with it? It's a reason he couldn't reach a binary conclusion on obstruction of justice.
Well, no, it was a prudential reason. One of the backdrop factors that he cited as influencing his prudential judgment that he should not reach a decision, which is different than citing the OLC, saying that but for the OLC opinion, I would indict.
I'm just going to stand by what he has written, and I ask others to read it as well. The last point I want to make is about Don McGahn. If you read the section here, pages 113 to 120, on Don McGahn's experience, the president wanted him to state publicly that the New York Times article was untrue, that he had not asked McGahn to fire the special counsel. McGahn refused, and there's some speculation as to whether he risked being dismissed or even resigning over this issue. And for you to suggest that this was some sort of a kabuki dance with Rob Rosenstein, I think the president's intent here was very clear. He wanted this to end. He told Lester Holt, going back to the issue that was raised by the chairman earlier here, the reason to get rid of Comey is because of the Russian investigation. I mean, over and over again, this president was very explicit, and it certainly is very expository in his style. So I don't understand. Let me ask you this. In conclusion, my time is up. Do you have any objections? Can you think of an objection of why Don McGahn shouldn't come and testify before this committee about his experience?
Yes, I mean, I think that he's a close advisor to the president.
Never exerted executive privilege.
Excuse me?
He may have already waived his.
No, we haven't waived executive privilege.
Well, at this point, do you believe you're saying Don? What about Bob Mueller? Should he be allowed to testify before this?
I've already said publicly I have no objection to him.
And Don McGahn, should he be allowed to testify?
Well, that's a call for the president to make.
Well, he's a private citizen at this point, as I understand.
Well, I assume he'd be testifying about privileged matters.
Well, I would hope that we could get to the bottom of this with actual testimony of witnesses after we've taken another close look to Hillary Clinton's emails. Thank you.
We might do that. Senator Lee.
In his classic dissent in Morrison v. Olson, Justice Scalia remarked that nothing is so politically effective as the ability to charge that one's opponent and his associates are not merely wrong-headed, naive, and ineffective, but in all probability crooks. And nothing so effectively gives an appearance of validity to such charges as a Justice Department investigation. That observation has, I think, been borne out time and time again over the past 2 years. Time and time again, the president's political adversaries have exploited the Mueller probe, its mere existence, to spread baseless innuendo in an effort to undermine the legitimacy of the 2016 election and the effectiveness of this administration. For example, on January 25th, 2019, Speaker Nancy Pelosi asked, what does Putin have on the president politically, personally, or financially? Mr. Attorney General, is there any evidence to suggest that Vladimir Putin, quote unquote, has something on President Trump?
None that I'm aware of.
On February 20th, 2019, former FBI Deputy Director Andrew McCabe said on national television to the entire nation that he thinks it's possible that Donald Trump is a Russian agent. Mr. Attorney General, is there any evidence that you're aware of that suggests even remotely that President Trump is a Russian agent?
None that I'm aware of.
Representative Eric Swalwell has repeatedly claimed that Donald Trump, quote, acts on Russia's behalf. Attorney General Barr, is there anything you're aware of to back that up by way of evidence, that the president acts on Russia's behalf?
None that I'm aware of.
So basically, we've heard over and over again on national TV, in committee hearings, on the House and Senate floor, and in the media. And we've heard about the president's alleged collusion with Russia. But what we have heard is as baseless as any conspiracy theory that we've seen in politics, any that I can think of. The only difference here is that the purveyors of this conspiracy were, in many cases, prominent members of the opposition party. That's concerning. Now, from the beginning, there were some indications that the Russia investigation was perhaps not always conducted with the absolute impartiality that the American people should expect and have come to hope to find in existence within the Department of Justice, especially given that the track record of excellence that the U.S. Department of Justice has shown. According to the Mueller report itself, the investigation into the Trump campaign began on July 31st, 2016, after a foreign government contacted the FBI about comments made by George Papadopoulos. Is that accurate, or were there other precipitating events that helped lead to this?
That is the account that has been given in the past as to how it got going.
Now, you've previously said that you think it's possible that the Federal Bureau of Investigation improperly spied on the Trump campaign. I assume that's a reference to the FISA warrant for Carter Page. Is that in mind, or are there other circumstances that you've got in mind there?
Well, one of the things I want to look, there are many people seem to assume that the only intelligence collection that occurred was a single confidential informant and a FISA warrant. I'd like to find out whether that is in fact true. It strikes me as a fairly anemic effort if that was the counterintelligence effort designed to stop the threat as it's being represented.
Was Carter Page under surveillance during his time working for the Trump campaign, which was roughly January 2016 to September 2016?
I don't know.
Was any other Trump campaign official under surveillance during that time period, to your knowledge?
Well, these are the things that I need to look at. And I have to say that, as I've said before, the extent that there was any overreach, I believe it was a few people in the upper echelons of the Bureau and perhaps the department. But those people are no longer there, and I'm working closely with Chris Wray, who I think has done a superb job at the Bureau, and we're working together on trying to reconstruct exactly what went down. One thing people should know is that the Bureau itself has been a little bit handicapped in looking back because of the pending Mueller investigation and the OIG investigation.
As we know, the FISA warrant for Carter Page was based largely on the so-called Steele dossier, and in particular on two specific facts about Page's trip to Moscow to deliver a speech in July 2016. First, according to the warrant, Page had a secret meeting with Igor Sechin, the president of Rosneft. Does the Mueller report confirm that Page met with Sechin?
Met with who?
With Mr. Sechin, with Igor Sechin.
Yeah, I can't recall, but I don't remember that. Let me just say that I want to stay away from getting too deeply into the FISA issue, because that's currently under investigation by the OIG.
Understood. Second, and more importantly, the warrant also says that Page met with Igor Devyekin in order to discuss what is referred to as compromat involving Hillary Clinton, against Hillary Clinton. Does the Mueller report confirm that Page met with Divyekin?
I don't think so.
Does it confirm that Page discussed compromat on Hillary Clinton with anyone?
Not that I recall.
So since the main evidentiary support for the warrant has been discussed by the Mueller report, which is sort of the gold standard of what we're discussing here, I'm glad that you're looking into it. I'd encourage you to look into why the FBI relied on this false information. And I hope you'll share the results. The public obviously has a right to know what happened here. The U.S. Department of Justice and the Federal Bureau of Investigation have a long history, and a long history of success that has been based on respect. They deserve to understand that there's not so much power that's been concentrated in that one agency, that the outcome of an investigation can depend on the whims of who might be assigned to it. They have a right not to believe that a particular investigation might be struck and paged, might not be tarmacked, might not be influenced by an improper consideration, politically or otherwise. Thank you, Mr. Attorney General.
Senator Whitehouse, I'm told we're going to have two votes beginning at 11:45. We'll do Senator Whitehouse, and why don't we just come back an hour later? We'll break for an hour and do the votes and have lunch. Senator Whitehouse.
Thank you, Chairman. Attorney General, you had a conversation with Chairman Graham earlier this morning in which you described the importance of, to use Chairman Graham's words, hardening our electoral infrastructure against foreign election interference. I ask you, is anonymous election funding an avenue for possible foreign election influence and interference?
Yes.
Let's turn to the March 27th letter, which you received and read March 28th, the Mueller letter? Correct?
Yes.
When did you have the conversation with Bob Mueller about that letter that you've referenced?
I think it was on the 28th.
Same day that you read it? When did you first learn of the New York Times and Washington Post stories that would make the existence of this letter public, the ones that came out last night?
I think it could have been yesterday, but I'm not sure.
When they contacted you to ask for any comment?
They didn't contact me.
Contacted DOJ to ask for any comment?
I can't actually remember how it came up, but someone mentioned it.
So you, at some point, you knew that the Mueller letter was going to become public, and that was probably yesterday?
I think so.
Okay. When did you decide to make that letter available to us in Congress?
This morning.
Would you concede that you had an opportunity to make this letter public on April 4th when Representative Christ asked you a very related question?
I don't know what you mean by related question. It seems to me to be a very different question.
I can't even follow that down the road. I mean, boy, that's some masterful hair splitting. The letter references enclosed documents and enclosed materials, right? Are those the same things as what you called the executive summaries that Mueller provided you?
With this letter?
Yes.
Yes.
It's all the same document.
I'm sorry.
When you talk about the executive summaries that Mueller provided you, they are the documents that were the enclosed documents with that letter, which we have not been provided.
I think they were.
We
have been provided them. They're in the report. They're the summaries in the report.
It's the language of the report in the report? There was nothing else that he provided you then?
I think that's what he provided.
Okay. If there is anything else, will you provide it to us? If it's different in any form, it's odd to be given a letter without the attachments to it when the attachments
I think they were the redacted versions of the executive summaries that are embedded in the report.
Can we get that just to be sure?
Sure.
Great, thank you. You agree that none of that material was either Grand Jury 6E or presented a risk to intelligence sources and methods, or would interfere or compromise ongoing investigation, or if it were affected by executive privilege? There
were redactions made in the executive summaries. But as I said, I wasn't interested in putting out summaries, period.
Well, you know,
frankly,
this is another hair-splitting exercise because Bob Mueller, who I think we all agree is fairly credible, actually described your letter as a summary. So you can say it wasn't a summary, but Mueller said it was a summary. And I don't think...
I wasn't interested in summarizing the whole report. As I say, I was stating the bottom line conclusions of the report.
Your letter itself says that it's intended to describe, I quote your words,
describe the report, meaning volume 1 dealt with this.
When you describe the report in 4 pages and it's a 400-page report, I don't know why you're caviling about whether it's a summary.
Because I state in the letter that I'm stating the principal conclusions. Let me also say that, you know, Bob Mueller is the equivalent of a U.S. attorney. He was exercising the powers of the Attorney General subject to the supervision of the Attorney General. He's part of the Department of Justice. His work concluded when he sent his report to the Attorney General. At that point, it was my baby, and I was making a decision as to whether or not to make it public, and I effectively overrode the regulations, used discretion to lean as far forward as I could to make that public, and it was my decision how and when to make it public, not Bob Mueller's.
With respect to the OLC opinion that informed Bob Mueller's decision, as he describes in the report, do you agree that that is merely an executive opinion and that under our Constitution, the decision as to what the law is made by the judicial branch of the United States government?
I'm sorry, could you...
With respect to the OLC opinion that informed Mueller's decision not to make a recommendation on obstruction, as he said in his report, do you concede that that is an executive opinion and that under our constitutional system, what the law is gets decided by the judicial branch of government?
Yes.
Is there any way for the OLC's opinion to be tested by the judicial branch of government to see if it's correct or not?
None that comes to mind.
And it could be wrong, could it not?
I guess hypothetically it could be wrong.
And certainly there are respected legal minds that disagree with it, correct?
Excuse me?
There are many respected legal commentators and professors and lawyers who disagree with it, correct?
It's very hard to find lawyers that agree to on anything.
So the interesting thing to me is that it goes on to say that because of the OLC opinion, we have to give the president an extra benefit of the doubt because he is denied his day in court where he could exonerate himself. That seems like a fallacy to me, because if you are the president of the United States, you can either waive or readily override the OLC opinion and say, I'm ready to go to trial. I want to exonerate myself. Let's go. Could you not?
How is this relevant to my decisions?
It's relevant
because I assumed that there was no OLC opinion.
Well, we have a report in front of us that says that this influenced the outcome. And in particular, it says it influenced the outcome because it deprived the president of his ability to have his day in court. And my point to you is that the president could easily have his day in court by simply waiving or overriding this OLC opinion that has no judicial basis. Correct?
Well, I don't think that there was anything to have a day in court on. I think that the government did not have a prosecutable case.
But well, Mueller obviously didn't agree because he left that up to you.
Well,
he said that he could neither confirm nor deny that there was a prosecutable case here. He left that to you. And when he did, he said, and you apparently have agreed, that this OLC opinion bears on it and that it would be unfair to the president to put him to the burden of being indicted and not having the ability to be charged.
I don't want to characterize how Bob's thought process on this.
I'm not asking you to characterize it. It's in his report. He's put it in writing.
I'm not sure what he means by that in the report.
With respect to the word, can I have a minute? I just want to nail down, you used the word spying about authorized DOJ investigative activities.
Are you talking about my testimony before the House Appropriations?
Yes.
Okay.
In the entirety of your previous career in the Department of Justice, including as Attorney General, have you ever referred to authorized department investigative activities officially or publicly as spying? I'm not asking for private conversation.
I'm not going to abjure the use of the word spying. I think My first job was in CIA, and I don't think the word spying has any pejorative connotation at all. To me, the question is always whether or not it's authorized and adequately predicated spying. I think spying is a good English word that, in fact, doesn't have synonyms because it is the broadest word incorporating really all forms of covert intelligence collection. So I'm not going to back off the word spying, except I will say I'm not suggesting any pejorative, and I use it frequently, as do media. When
did you decide to use it? Was it off the cuff in the hearing that day, or did you go into that hearing intending to use the word spying?
It was actually off the cuff, to tell you the truth, and when the senator, the
congressman, probably?
Well, from Schatz, from Hawaii.
Oh, Sarah? Shaheen?
No.
Whoever it was, go ahead.
Yeah, when he challenged me and said, "Do you want to change your language?" I was actually thinking, like, what's the issue? I don't consider it a pejorative, but if. Frankly, we went back and looked at press usage, and up until all the FAW outrage a couple of weeks ago, it's commonly used in the press to refer to authorized activities, such as referring to the FISA court as the spy court.
But it's not commonly used by the department.
What?
It is not commonly used by the department. My time is
commonly used by me.
Thank you very much. We'll come back at 10 till 1. Thank you.